In Stupid Letter Time, we deal with an article from jacobin.com, which says that the Supreme Court's major question doctrine is a threat to democracy. Okay, so we're going to do this thing again. All right, so the major questions doctrine, let's just summarize, is an idea that we don't hide mountains in molehills. If the Congress wants to authorize something, they're going to make it clear. And if they want to authorize a big thing, they're going to make it clear. They're not going to hide the ball in, generalized language. So, for example, if a law said, for example, something like the CDC may take all measures for the public health, despite the broad language, we might question whether or not Congress really meant to include certain things that might fall within the definition of all. Because, what exactly does that mean? And we think that maybe Congress perhaps didn't exactly mean exactly what they wrote, or they should have been a little bit clearer. So we're going to raise some questions. So we have some problems with this idea that maybe we shouldn't hide mountains and molehills. Maybe, for example, if we want to force people to take a vaccine, maybe we should say that with a little bit more clarity would be one of the ideas, but I don't know. So let's read this stupid letter time. On June the 30th, the Supreme Court invalidated the Biden administration's student loan forgiveness program, which promised to wipe off $10,000 off of borrowers earning less than $125,000 a year and $20,000 off debt of Pell Grant recipients, in total $430 billion. So right away, you can see why we're talking about the major questions doctrine. We want to spend $500 billion, okay? $500 billion. Now, that is still, even today, a significant amount of money. All right? So if we're going to be like, okay, $500 billion, we'd like Congress to speak with just a little bit more clarity before spending $500 billion. What is your support for this? The language is a little bit unhelpful to this point. While the primary victims of the Supreme Court decision are debtors, another long-term danger stems from the reasoning behind the decision. The Biden program was unlawful, according to the court, because the 2003 Higher Education Relief Opportunities for Students Act, also known as the HEROES Act, because it wouldn't be Congress if we didn't get it out to spell a cool word. So, of course, it's the HEROES Act, which authorizes the Secretary of Education to waive or modify obligations during a national emergency, could not possibly authorize debt cancellation on this scale. If Congress wanted to permit something so vast and sweeping, it would have said so explicitly. Yeah, that's basically the idea for the major questions doctrine. You got it, right? There is a difference between, small things and big things as far as the Supreme Court is concerned, and the amount of clarity we want from Congress before we do this massive thing, because we think it's possible that maybe the executive branch might exploit language that was intended for perhaps a more limited purpose and be like, well, it says all, and be like, that means everything. Congress authorized us to do all the things. Because Congress said everything, they meant everything. And it's like, look, asshole, they didn't really mean exactly that. And you want to spend $500 billion. So, we'd like a little bit more, please, before we think that's kind of what Congress had in mind. The idea that Congress does not hide elephant in mouse holes is called the major question doctrine. On its face, it's consistent with Supreme Court precedent. It sure is. In reality, it empowers the Supreme Court and conservative majority, those evil conservatives, to veto rare executive actions that could have actual social impact. Well, when it's to the tune of, billions of dollars or otherwise massive in scope, yes, that is exactly the problem. Executive actions. This is a problem, right? We want Congress to be the one that's going to authorize things that are massive. And you want to do it through the executive. You just want a king-like person to come in and dictate this massive sweeping thing. That seems like it's taking power away from the legislature and giving it to the executive branch, which is exactly what we're trying to avoid, right? We want the legislature to be the one that is going to have massive impact, because through the policies of debate and all the rest of it, rather than just be like, okay, this is a good idea. So yeah, if it's an executive action that has massive social impact, that kind of is the problem. Yes, we'd rather it be Congress. Getting the federal government to do anything useful is harmful enough at best. Thanks to major question doctrine is about to get a lot harder. See, this is the thing, right? They want the executive branch to just do whatever the hell they want. Geez, it's really inconvenient to get Congress to pass this legislation. Don't you know how hard it is to get Congress to pass this legislation and get them to authorize $500 billion of financial expenditure? Man, getting 535 people to agree on something is really, really challenging and inconvenient, man. It's almost like our founding fathers set it up that way, with two different houses elected differently in different ways to different terms, representing different groups of people. And they both have to agree before, we make these sweeping changes. So yeah, it's difficult to get the federal government to do something. Some people say that's the idea. This guy over here is like, no, that's not the idea. We need the president to be able to make these policies unilaterally without Congress. Congress is anachronistic. It is best left in the past, I guess. Okay. It was far from surprising to see the Biden administration lose the student loans case, known as Biden versus Nebraska. The well-known conservative leanings of the Supreme Court aside, those mean conservatives who actually want to, conserve things. Both Biden and other senior Democrats set themselves up for failure by repeatedly stating the president lacked authority to cancel debt. Yep, the president himself said that. Biden himself said, I can't do it. It's illegal. Senior Democrats themselves said he can't do it. It's illegal. And then he tried to do it. And the Supreme Court's like, he can't do it. It's illegal. For example, Chief Justice Roberts, who wrote the opinion, famously quoted the then Speaker Nancy Pelosi's remark from 2021 saying, quote, people think the President of the United States has the power of debt forgiveness. He does not. He can postpone, he can delay, he does not have the power. There has to be an act of Congress. Far-right conservative Nancy Pelosi also thinks this idea is problematic. But it's the Supreme Court that's the problem, apparently. The slow rollout of the plan itself also gave conservative legal activists ample time to plot their attack, otherwise known as challenge it for being illegal. Just like Nancy Pelosi said, with the aid of Democratic incompetence, the Supreme Court's conservative majority developed several arguments for striking down the plan. The question here is not whether or not something should be done, it's who has the authority to do it. Correct. Right? Should be is an issue of policy. The Supreme Court doesn't really do policy. The Supreme Court doesn't really do should be. They really do more like is. What is? So should we forgive people's loans? But did Congress? No. Through its broad interpretation of the HEROES Act, he asserted, the executive was seizing power of the legislature. Sounds a lot like that. You know who else agrees? Apparently, the legislature does. You know who else also agrees? The president does. The very same president who's trying to use the power now says it's an abuse of power. But it's the Supreme Court who's evil for agreeing with Nancy Pelosi and Joe Biden, I guess. The HERO Act allowed the president to waive or modify programs through a national emergency, but the plan that they actually did, Roberts said, has modified provisions of the HEROES Act only in the same sense the French Revolution modified the stance of the French nobility. This was a little bit more than a modification. This was whole replacement. This was taking out the red pen and striking out huge portions of language and writing in different language and being like, that's a modification. It's like you've modified it so much there's nothing left. And you don't have the power of the legislative pen. So this goes beyond modification. And also Roberts notes that a few weeks before the decision, Biden had said that the pandemic itself was over, which undermined the rationale. So we're doing it because of the pandemic, but the pandemic is over. Apparently, Supreme Court super evil for this decision somehow. The overarching problem, according to the 6 conservative justices, was that cancellation of the $430 billion in debt was a decision of such magnitude and consequence, and a matter of such earnest and profound debate, it must rest with Congress itself, or an agency that would act pursuant to a clear delegation. Maybe before we spend $500 billion, we'd like something a little bit clearer. If Congress wanted such bold executive action, it would have said so. Roberts refers to this logic as the major question doctrine, a term first used by the Supreme Court in last term in West Virginia decision, but previously articulated in prior cases. The shared intuition behind the cases, Amy Coney Barrett, is that a reasonable speaker would not understand Congress to confer an unusual form of authority without saying more. So Congress wrote some language, they wrote some language, but the executive branch took it well past the breaking point. And so how about no? How about we need Congress to authorize the $500 billion? In both Roberts and Barrett's opinion, discussions of pragmatism and Supreme Court precedent are much more prominent than discussions of the Constitution's original meaning. Well, I mean, precedent is part of the game when it comes to the Supreme Court because, we do work on a precedential system because of common law. So, also, what would this mean if they were allowed to do this is a pretty reasonable question because, geez, this seems like a pretty excessive thing. So what would be the limits of this? But apparently discussing that is bad for some reason. Nevertheless, Roberts and Barrett trace the major questions doctrine to separation of powers. That makes sense. The Constitution gives the power of the purse to Congress. Only Congress can spend money. So, yeah. The conservative justices therefore believe the major questions doctrine preserves the Constitution's promise that the legislature legislates and the executive enforces the law but doesn't make it. That all sounds about right. Also, that money should only come from the legislature passing an appropriation bill rather than the president just saying, here's $500 billion from nowhere. On the other hand, an honest originalist could feel uncomfortable with the major questions doctrine. Although the framers of the Constitution deliberately vested all legislative power in Congress, not the executive, which, seems kind of clear, is debatable at best to conclude the judiciary was supposed to police congressional delegation to the executive when the executive acted on matters of earnest and profound debate. So we're questioning judicial review, I guess. We're going all the way back to Marbury versus Madison, I guess. Indeed, the original point of originalism, as popularized by conservatives starting in the 70s and 80s, was supposedly to cut down on judicial interference of the framers. The major question doctrine runs squarely against the purpose. It's a judge-made concept that gives more power to judges. It's a concept that says, okay, we're going to interpret the Constitution that says legislative power belongs to the legislature. And we can't help noticing that the way you've modified the student loan program is by crossing out huge portions of text and writing in different portions of text, which seems suspiciously like what Congress does. Also, it's $500 billion. So we find the support for it a little bit wanting. But apparently this is a majorly bad thing, I guess. Apart from dubious roots in text, history, and structure of the Constitution, although seems pretty logical to me, the major questions doctrine poses serious threats to functionality of the federal government. As Justice Kagan emphasized, Congress delegates to agencies, often broadly, because agencies have expertise Congress lacks, because at times circumstances change, and agencies are better able to keep up and respond, and because Congress knows if it had to do everything, many desirable and even necessary things wouldn't get done. Yeah, okay, so delegating broadly is an idea, but still, delegation to do what is still the issue, right? You can empower an agent to act broadly, but still it's within the scope of the delegation. And in this particular case, the nature of the delegation was rewriting the statute, which is a bit of a problem. In the context of student loan forgiveness, it seems as though the HEROES Act was an example of broad delegation. In 1991 and 2002, Congress passed legislation providing for student loan relief for Americans serving in the first Gulf War and those affected by 9/11. Well, fair enough that Congress wants relief for those things. Maybe we should have relief for those things. Maybe those things are good. And Congress passed those things, so like, okay. In 2003, as Justice Kagan notes, with these one-off statutes in short-term memory, Congress decided there was a need for a broader and more durable emergency authorization. So the HEROES Act didn't propose any particular emergency, leaving this at the discretion of the president. It's irrelevant, they say, that Biden said that the pandemic was over soon after announcing the program, because a formal state of emergency still existed when the program was announced, which is all that HERO Act requires. So even though the emergency was over, shortly after we announced the program, it's present enough to continue spending the money. Yeah. To be sure, it might be unwise for Congress to provide such broad delegations of power. Executive agencies are not accountable and can be captured by industries they're supposed to regulate. So even this article and stupid article time notes that maybe giving all the power to the agencies is not the best. That's okay, we'll give all the powers to a president. Nothing could possibly go wrong. But this has long been a complaint for the current elected Congress or elected president, not the unelected Supreme Court. The court waded into this territory in the 1930s, undermined the New Deal, which, yeah, they should have, because a lot of that stuff was not legal. But since 1937, when they threatened to pack the court, it's largely left to elected branches to figure out how they should divide or share powers. So, yeah, the Supreme Court was doing its thing and doing its job, and then they threatened the Supreme Court, and they backed off a little bit. And then they're like, maybe we should actually give this another go. And now you're threatening to pack the court again. So you're bringing back those old tropes. Do what we want or else. Among other examples, the Supreme Court has upheld delegation to the FCC to regulate in the public interest, to the Secretary of War to define excessive progress generated by secretaries, subcontractors under wartime, to the Federal Power Commission to set just and reasonable rates, to the EPA to issue air quality standards requisite to publish the public health, and U.S. Sentencing Commission to set federal sentencing guidelines. For better or worse, almost the entire machinery of the federal government has come to rely on expansively worded delegation. Expansively worded, of course, doesn't mean infinitely worded. There are limits. We found a limit, right? We found a limit. It's like, okay, we want a little bit more. And the fact that the Supreme Court has upheld delegations with respect to this in certain times, in certain places, well, maybe those were fine in those times and places because that was not excessive. But we found a limit. This is why the major question doctrine is so dangerous. It allows the Supreme Court to look at almost any consequential action by an agency and question whether it was really authorized by Congress. Oh, the horror. Oh, the horror. We have to figure out whether or not the agency really had power to do this thing by Congress. Wow. What a shame. Prior to Biden, the conservative Supreme Court has applied the doctrine to validate the EPA's Clean Power Plan and the Center for Disease eviction moratorium because it made absolutely no sense at all. The eviction moratorium was completely illogical. But they think it's good. They think it's good because it's good policy. Not because it's good law, but they think it's good policy. In each case, the court assured the public it wasn't declaring these policies to be unconstitutional. It was only requiring Congress to be more explicit. Before we give the CDC the power to deal with rent moratoriums, which sounds kind of outside the CDC's wheelhouse, maybe you'd want more explicit language. The problem, of course, is that Congress can rarely do this. Because small factions can easily sabotage legislation, the Senate is a giant obstruction machine, and any remotely progressive legislation activates fierce resistance from powerful donors. So the problem is we want Congress to act, but we can't get them to act. Because we can't get our policies through Congress. The Congress won't do what we want. We can't get them to do our bidding. So the Supreme Court saying talk to Congress is no answer because Congress won't do what we want. So we just need the executive to come in and do it because all these pesky elected officials, man, they're really slowing our roll. In the context, the main achievement of the major questions doctrine will be an even more dysfunctional federal government. Usually, the ability of the judiciary to implement dangerous doctrines, such as this, is limited by the Supreme Court standing rules. These rules require a plaintiff show a real or imminent injury stemming from government action they seek to invalidate. They cannot simply say this is illegal. Yeah, that's standing doctrine, a doctrine we've discussed many times. Some of you guys don't believe in it, but that's okay. I do. But yes, we'd like to have standing. Standing would be good. But in Biden versus Nebraska, the Supreme Court accepted a highly dubious theory of standing, allowing the state of Missouri to bring the suit on behalf of the Missouri higher education lawsuit, a state-created corporation that's financially and legally independent from the state, saying Missouri itself suffered no plausible injury. Well, the Supreme Court kind of disagreed. It's like, well, this is an apparatus of the state, and the state has the ability to have control over it, and so the state itself is injured. So, but this is a highly dubious theory somehow. If the Supreme Court is willing to make it easy for states to sue the federal government, the major question doctrine will be coming soon to a courtroom near you. More menacingly, conservative legal activates will accelerate toward their long-standing goal of dismantling the administrative state. Yeah, that is definitely something I'm interested in. I don't like Chevron very much, and I don't like Wickard v. Filburn very much. Yeah, I don't really like the administrative state. This is what Trump was talking about when he was talking about the deep state, like the administrative state that exists and perpetuates and does things outside of elected authority and just kind of rolls and continues and does whatever it wants to, often outside the control of the president as well, incidentally, which is also another problem. But these are trained bureaucratic officials. We can trust them. We don't need that pesky democracy. We don't even need a pesky president. We just need these officials who are beyond the power of being elected to just do whatever is good in the interest of the state. Okay, well, that's pretty dumb. Thus, that brings us to the end of this article dealing with stupid letter time, which says that the major questions doctrine is a threat to democracy, not realizing that they themselves are calling against democracy. Like, they think democracy itself is a problem because they can't get Congress to do what it wants. So apparently, the real threat to democracy is the Congress itself, because Congress won't do what we want. And now the judicial branch is saying, hey, Congress didn't authorize them, get them to do it. And be like, we can't get them to. We can't get Congress to do what we want. It's a major threat to democracy. We can't get Congress what we want. You know what would not be a threat to democracy? What if we created these agencies that exist and persist beyond elections, beyond presidents? What if these non-elected bureaucratic officials who are there year after year, decade after decade, what if they were the ones that made decisions? That would be the best way of preserving democracy. The unelected bureaucrats, not the Congress, not the Supreme Court, but the bureaucracy. Bureaucracy is best democracy, article seems to suggest. I am dubious of this proposition. And that, for the moment, brings an end to discussion of this story.